Like to call to order the Board of Adjustments meeting for Thursday, December 4th. The time is 5:47. This is a regularly scheduled meeting of the Board of Adjustments that has been properly noticed for the Pinehurst Board of Adjustments. We do have almost all of our permanent members here today. We will need to seat one standing member for Louise Mercuro, who is not here with us. So we will have a quorum and we'll be able to do business today. I'll ask the permanent board members to introduce themselves, and then we'll fill that last seat. So I'll start from my right.
Devin McFarland.
Bruce Hieronymus.
Bill Calmer.
I would look for a motion to seat Ed Kragulski, who is our alternate for seating and being a member of today's hearing for the Board of Adjustments.
I move to seat Ed Kragulski on the Board of Adjustment for today's meeting.
Second.
Motion by Devin, second by Bruce. All in favor?
Aye.
Motion carries. Welcome, Ed. Thank you. Thanks for being here. A reminder that today's procedure is being videotaped and live streamed, so be sure to speak into the microphone for all here today and for the record. We do have minutes from the last Board of Adjustments meeting to approve. All should have received a copy. Any comments on those minutes from the August 7th meeting as recorded? If none, can I have a motion to approve those minutes as written?
I move to approve the minutes as written.
Second.
Motion by Bill, second by Bruce. All in favor?
Aye.
Aye.
Motion, the minutes are approved. I now move to recess the regular, or can I have a motion to recess the regular meeting and to move into our public hearing for today?
Motion to recess the regular meeting and enter the public hearing.
Second.
Motion by Bruce, second by Bill. All in favor?
Aye.
Okay, we have entered into the public hearing. Reminder today before we turn to staff, a couple general notes as we are in a quasi-judicial hearing. I first want to ask if any member of this board needs to recuse themselves due to either ex parte communication, conflict of interest, or financial interest in the outcome, or have already made up their mind. Seeing none, we can continue. Reminder that our decision today must be based on competent, material, and substantial evidence in the record. To the public, anyone who speaks here today should be someone with standing and be able to provide material relevant to the application and the standards. Opinion will not be admissible as testimony in this hearing unless someone is designated as an expert witness. We'll now look to staff and first swear in staff before they make their presentation. Michael, please raise your right hand. Do you swear or affirm that the presentation you'll make today to this board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed with the staff presentation. Oh, sorry, Alex. Okay, Alex, come on in. Do you swear or affirm that the evidence and presentation you'll give to this board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Now, please proceed.
All right. Here we go. So the purpose of this public hearing is to receive testimony for a variance request from the Pinehurst Development Ordinance, Section 9.2A, Table of Dimensional Requirements for the property, which is located at 35 Salem Drive. Further identified as Moore County PID number 000-19828. This property is located within the R10 zoning district. Specifically, the applicant, Brian Allard, is requesting a variance to reduce the rear yard setback for an accessory structure from 10 feet to the 5-foot requirement for a storage shed. And just to go over what Matt went just keep it going. Matt's gone over the evidentiary hearing process. We are in a quasi-judicial hearing. Must be factual relevant. If you're a witness, you need to be an expert witness. No opinions are admissible in this type of hearing. Your staff acts as the initial witness, and the applicant will be given a time to speak for their case. And at the conclusion of the hearing, the board shall make its decision based on evidence submitted and the testimony given while adopting finding of facts on all standards. So as you see here, this public hearing was noticed in accordance with the Pinehurst Development Ordinance and North Carolina General Statute 160D 406. Our subject property is the property that is hatched right there on 35 Salem Drive. The red outline properties are the adjacent property owners that were notified of the variance request in the hearing. So the request is to reduce the rear yard setback for an accessory structure from 10-foot to 5-foot requirement in the R10 zoning district. The R10 zoning district has a minimum rear yard 10-foot setback. The accessory structure was permitted as a storage shed, which is not allowed to have any dimensions greater than 12 feet. Sheds are allowed to encroach up to 5 foot into the rear setback. Upon inspection, it was determined the shed did have a dimension that exceeded 12 feet, therefore making it an accessory structure. It took it out of the shed category. So this triggered the 10-foot rear yard setback for an accessory structure in the R10 zoning district. A little background on the property. It was created as part of the subdivision by Pinehurst Inc. in January 1973. And it is indicated in map book 10, page 41 on file with the Moore County Register of Deeds. Records indicate that the home was built in 1988. The subject property is approximately 12,825 square feet or 0.294 acres, which complies with the minimum lot size requirement of 10,000 square feet for the R10 zoning district. A little more background, the applicant applied for it and received a building and development permit for a storage shed, accessory structure with no dimension greater than 12 feet. Upon inspection by village staff, it was observed that the accessory structure exceeded the permitted 12-foot dimension. Measurements done by Village of Pinehurst building inspector confirmed the shed had a length and width of 12 feet and 2 5/8 inches, which exceeded the maximum 12 feet. The accessory structure is located 6.1 feet from the property line, creating a 3.9-foot encroachment. After the setback encroachment was discovered, staff contacted the applicant, provided options to bring the storage shed into compliance. Some of the options that were given was modify the structure so that no dimension exceeds 12 feet, contact the adjacent property owner to the south, which is a vacant property, to purchase additional land, or apply for a variance. The applicant decided to apply for a variance, which was done last month in November 2025. Here's the aerial view of the property, which is outlined in red. As you can see, that the vacant property to the south was the one that was suggested maybe contacting for additional property. You can see here on the inset, this is the site plan, but the inset to the right shows where the storage accessory building is, or accessory structure, excuse me, is in relation to the property line. So we're at each corner 6.1, 1 6.1, and 6.15. And here's a couple pictures of said storage shed, and you can see on this picture on the right how where it is in relation to the existing fence. A couple more pictures of where it is in the yard, and some of the construction on the interior of the shed. So we're on to the standards of review here. The Board of Adjustments shall not grant a variance unless and until it makes findings that all of the following standards of review have been met. Unnecessary hardship would result from the strict application of the ordinance. It shall not be necessary to demonstrate that in the absence of a variance, no reasonable use can be made of the property. The hardship results for conditions that are peculiar to the property, such as location, size, or topography. Hardships result from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for the granting of a variance. The hardship did not result from actions taken by the applicant or the property owner. The act of purchasing a property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. And number 4, the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. So your action, you have the authority to subpoena witnesses and request additional information, continue the public hearing on the requested variance, grant the variance, deny the variance, grant the requested variance with conditions. In granting any variance, the Board of Adjustments may attach appropriate conditions, provided the conditions are reasonably related to the request. Any decision to grant or deny the request shall be accompanied by findings of fact stating the reasons why the request meets or does not meet each standard of review, and it must be a 4/5 vote to grant a variance. Staff does not offer recommendations on variance requests. The decision's solely up to the Board of Adjustments. At this time, I would like to submit the following into the record: the staff report with attachments and exhibits, the presentation, and the application and the applicant's materials and exhibits. And I will take any questions from the board at this moment.
We accept those materials into the record. Thank you for the presentation. To the board, any questions for staff on its presentation? Yes, Bill.
I just have one question. In your report, you mentioned that upon measurement by the building inspector, the dimensions exceeded 12 feet, but was that in one dimension or in two dimensions?
I think it
both
was
length and
I
width?
think it was 2 different dimensions, but they both were 2 5/8 inches over. Yeah,
Thank you.
length and the width. Yeah.
So if we could, just before we get to the probably arguably the most important testimony, which will be that of the owner and the applicant here, I just wanted to make sure that the board did understand, because it can be confusing, again, if you don't do this every day like we do, the distinctions here that are made. All right, so any building that is 12 feet or less in any dimension is classified as a storage shed. And obviously, because of the smaller dimension, they're afforded a little bit closer setback to a neighboring property. The applicant and the owner here in this case did secure a valid development permit to pursue that development on their property. They acted in good faith effort on the reliance on that issued building permit. We've already highlighted, what happened upon final closeout of that development permit. And so with that exceeding that 12-foot dimension, it now is classified as an accessory building, which has a little bit more stringent of a setback of 10 feet from the property line. So I just want to make sure the board does understand those distinctions there.
Thank you.
Alex, for clarification, so the setback for the storage shed would be 5 feet? Is that what you're saying?
It could be up to 5 feet, yes.
That's very helpful.
Michael, can you go to the slide that has the plat on it? Are the dimensions shown there to the wall of the structure or the roof line? Do you know?
This here,
Yes.
that is the distance between the fence or the property line and the rear of the structure.
But do you know, is that because there's a pretty decent overhang on the back of the structure.
Overhangs are allowed to encroach.
Okay, so we're talking about the wall, the rear
Yep.
wall, that's the distance, okay. I thought that, but I
Yeah,
just wanna confirm.
you're right, there's some extensive overhang, but that is allowed.
Okay.
3 feet's allowed.
Yep. Okay. Well, we can continue to ask staff questions, but if no other questions for staff, at this point, I'll call the applicant forward to be sworn in to be able to give their testimony. You can come sit come to the microphone, stand, You,
Either
yeah,
way.
come here, and then you may want to sit, but stand to be sworn in, please. First, state your name and your address, and then we'll swear you in.
Brian Allard at 35 Salem Drive.
Darcy Forshaw Allard, 35 Salem Drive.
Okay, please raise your right hand. Do you swear or affirm that the evidence you'll give to this board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated and make your case before this board. Thank you for being here.
Please pull the mic closer to you.
Okay. So Michael covered pretty much everything. I permitted it as a shed. I put it at 6 feet off instead of 5 feet off. It just worked better for our yard. I could keep some more trees right behind the fence, because I like to have a little bit extra barrier. Had a concrete contractor come in and pour concrete basically between the deck and up to the fence, which of course I did the calculations for the impervious surfaces. It's not in violation of that. Where the shed is on a 3-inch raised platform to keep it out of the water, rainwater, snow, whatever. So it's a shed. It's 12 feet, 2 5/8 inches. The concrete was completed. My contractor came in, put rebar in, put anchor bolts in the concrete when he poured the slab to hold the wall in place, and moved on. So then I started buying materials and started erecting this. Didn't realize that this slab is 12 by 12, because I had spoken with the contractor, said, hey, I'm going to put a 12 by 12 shed up. I'm putting this size sheathing. I forget what the dimension is, because it's not 1/2 inch, but 19 somethings. And then I'm putting a 3/4 inch trim board on. This is what I'm doing. I got to have 12 by 12. I didn't pay attention to what he poured. I just started building. You know, you lay out a board, you mark it, at the end you cut it. You know, I never really noticed that I was actually over the dimension. So I'm get done, call in for the inspection, and then they find that it's a touch over. So it's built as a shed. It was intended as a shed. It didn't go to 14 feet. I didn't go to 16 feet. I didn't blatantly break the rules. So,
We just didn't take into account the siding.
Oh, please
and
use, sorry, please use the microphone.
Right,
Thank
we
you.
just didn't take into account that the siding and the trim would go beyond that 12-foot.
Right.
So, you know, and he's, you know, the application in Michael's presentation, I think, covers pretty much everything. Other than that part, you know, so I had contracted to have the concrete done, told him what I was doing, and just did not catch that he had poured it so that I could not overlap, because the siding has to overlap, and then the trim goes on top of that.
To prevent
Yeah, otherwise,
rain damage,
I mean, you just
especially with that wood siding.
because it has to be T111, because it must match the house, and the house is T111 wood. So per the planning board, I've got to match, or the planning requirements, I've got to match the house. So that's what we did. I would have preferred metal, but that's neither here nor there. Doesn't matter. So that's how we land where we are. I guess what I've got to say is again, you know, the concrete contractor kind of set me up to be here. I didn't measure, I didn't pay attention as we erected it. I think some of the pictures, the inside pictures, will show where the bolts are. So the treated green wood is at the edge of the slab, and you'll see that the bolt is not even centered on that. So if I had even paid attention and noticed, hey, this is going to be oversized, I really couldn't shift that wall in and utilize that bolt. So I didn't notice that, but even if I had, I would have been in a pickle. I wouldn't have known what to do. The other pictures will show you that it really is, it's better built than a shed. I mean, it's a structure. I got mechanical fasteners everywhere there is. So yes, I'm basically looking for the setback requirements to be varied. I'm just reading through my application here. Really, that's where we land. I mean, it is I think the ratio that I'm over is like 0.000 something percent. So, it would be just a crazy undue hardship to have to try to do something with this, because I don't know what I would do to get it in compliance.
Yeah, at this point, I'd be completely dismantling the building to move it 2 inches. Then you risk the water damage from the wood siding with all the water, because it's a rainy area.
Mr. Allard, a question for you is, maybe you can go, staff, to the picture that shows the whole slab. For clarification, when you say the slab, so the building itself is the 12 by 12, say, plus 2 5/8. But obviously, there's a lot more concrete there. So I'm missing something. Maybe you could just help me understand.
So this table is the slab,
Okay.
and this here is where the building is raised 3 inches. So the building,
So there's additional concrete under there that we can't see in this.
right.
I don't know if you can zoom in, but there's a,
It's a slab on top of a slab, basically.
yes, that's good
Yeah,
wordage.
okay.
Or, yeah, it's one giant slab, but
see it.
it's raised, it's elevated, it's a plateau, it's a 12-foot
Yeah,
by 12-foot
okay.
plateau. That's the
see.
word.
Looks like it could be a nice small home.
Honestly, I think it's prettier than the original house. Yeah.
Okay.
Yeah, and really, the 12 by 12 limits, I said, well, I don't want to buy some cookie cutter, I don't want to degrade any other building, some prefab junk. I want something that looks nice. I want something that fits in to the resort community, add value to the property. So yes, I definitely intended to go 12. That slab, it
Right, understood.
ended up larger without even realizing it.
If I could, I would like to validate the applicant's comments regarding another requirement
Please.
for storage sheds. Again, it's just the term used. Obviously, this is a little bit different. I know you think storage shed, your minds mostly probably do go to the prefab structures mentioned. So if you are doing a structure that is 12 inches or 12 feet or less in any dimension, there is that architectural compatibility requirement that it be compatible with the existing or the principal structure. Accessory buildings, which again are those that are larger than that, we don't have that ability to regulate, so we don't regulate that compatibility. Right, so I do want to make sure that the board knows that was a valid comment made by the applicant. Also, and I should have mentioned this before we move to the applicant's testimony, but the timing, if you see the timing of all that, the applicant's been very amenable to work with us and since finding the dimensional snafu, if you will, because we did have other applications and things that we were processing, and we wanted to make sure that they had sufficient enough time to, as well as staff did too, to look at all options that would be afforded. There are provisions in the development ordinance that allows myself to modify certain dimensional criteria. Setbacks are one of those dimensional criteria that I'm allowed to modify. However, it is quite limited, and that limit is 2 feet or 10%, whichever is less. And this exceeds that. However, if that modification were to include the dimensional measurement between a storage shed and a accessory building, I would have been well within those means, but it's not allowed. So this is a lot of the vetting that staff and the applicant tried to work through before we ultimately arrived at
Yeah,
the
that's
request
helpful.
before you.
Thank you. Any other questions for the applicant?
I have a question.
Yes, Bruce, go ahead.
I'm surprised that you didn't call your concrete contractor to be an expert witness. That's a joke.
He might have.
Bill?
Yeah, I just have one clarification, just to make sure I'm looking at this right. The lot, your lot itself appears in these pictures to be relatively level. There's nothing about that particular topography or anything that drove you to place the structure in any particular place. It was just, am I correct, I guess, is that?
Visually, I wanted it out there. I wanted to block the road when I looked out my back door. And then that area is low. Our concrete guy did, what's the right word? Level it so that any water that hit there went out and away from the house, away from the building.
It definitely puddles there, and if on the right picture, if you look straight to the side, the fence, which would be to the back of the picture, that is the east side of the property, and the city did, several years ago, put in some kind of storm drain between Salem and Morganton, with 2 catch basins out on Salem. That's where that pipe runs. That also puddles up terribly in rain.
So it is lower on the, what I would say, the left-hand side of that.
But really, that we needed to crowd to this side, and then the concrete, when we did the slab, yes, that elevation, and then he tapered it so that it would run off. So that yes, I mean, it puddles all around
That whole section of Morganton is getting worse and worse.
Yeah.
With puddling. I just wondered if it came back toward your property. Since you have the vacant lot there, probably you don't see it.
Correct. With the vacant lot, thankfully, that we don't see that there, but the side yard, that, again, that picture looking straight through to the, that definitely gets some water.
Yeah, yeah, it does. And now it's nice because we can walk out there and it's dry. You can, otherwise before all that water would bring up the little bits from the pine straw. It just wasn't nice to walk out there.
Yeah, and then for the placement of a shed, yes, it really needed to be over that.
Okay. Appreciate it. Thank you.
Any other questions for Mr. and Ms. Allard? So you can stay, you don't have to leave for our deliberation. We'll leave the public hearing open.
I do have, Mayor, before we
Yes,
leave
sir.
our part, I did have several conversations with neighbors, of course. I've got a text from a neighbor that says they have no issues with it. I don't know if that matters to you or not, but I did print that off.
Would the neighbors need to be here for that to be admissible as evidence?
So, unfortunately,
Yes.
we would not be allowed to accept that. If there were any questions of said person who make any comment, they have to be present in case there was another party or person was standing.
I'm sorry, are we able to bring the,
Then they would be able to have that opportunity to cross-examine, but
Oh, okay.
it's,
he's
I
in
see.
support, so
Yeah.
he doesn't care. Oh, okay.
Being treated as quasi-judicial, basically it needs to be firsthand.
Okay, gotcha.
So at this point, as I said, we'll leave the hearing open. Mr. and Ms. Allard, as Michael shared, and I'm sure you're familiar with, our review is based on these four conditions, right? And this is a reminder also for staff as we're preparing to discuss 4 standards of review that all have to be met. So even if we believe that you acted in good faith, these are the standards that we have to be met according to the ordinance. A necessary hardship would result from application of the ordinance. The hardship results from conditions that are peculiar to your property. et cetera. The hardship does not result from actions taken by the applicant or the property owner, and that the requested variance is consistent with the spirit purpose of the ordinance. So that's the means by which we evaluate it. We treat each case independently, and regardless of other decisions, your case is looked at just based on the merits of your case alone. So to summarize the facts so far for the board as we look at discussion,
Chair, if I could.
Yeah.
We do need to open up for anyone else to provide any testimony.
Any other testimony? Is there anyone else present that would like to provide testimony before this board today? Please come forward. You can come to the microphone, state your name to be sworn in.
Randy Merzen, 40 Salem Drive, property just north of 35 Salem.
Okay, please raise your right hand. Do you swear or affirm that the evidence you shall give to the board on this day for this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please proceed.
So I do not object to anything that has taken place on the property of 35 Salem Drive. He's done a fine job in building this structure. That's my testimony.
Okay, thank you. Thank you very much. Good, thank you. Okay, so we have everything followed the right process. It was submitted as an, I'm going to say it correctly, a storage shed, which would not exceed 12 foot in any dimension. Then once constructed, it was determined that it could no longer be called a storage shed. It had to be called an accessory dwelling. And based on that, the setback of the storage shed was not allowed. Sorry?
It's just, he picked up that you mentioned accessory dwelling instead of accessory building.
Oh, sorry.
Accessory building.
That's a natural
that's-
reaction when we hear accessory
Good-
dwelling
good
to us,
caveat.
sorry.
Sorry, accessory building. No, that's good. That's your training. So accessory dwelling, and here we are in a more restrictive setback for accessory building than a storage shed. So the 4 conditions are before you. As you think about, we'll have some discussion, but in ahead, as you think about a motion, here are your options to approve the variance. You can approve the variance with conditions. Note that a variance does require 4 out of 5 votes for the motion to carry. We can also continue the meeting to another date if we feel like additional evidence or testimony is needed to make our decision, and then we can deny the variance. But do note, as on the guide provided for us for each of those 4, it's not just making a decision of does result, does not result, but you must state the reasons why. So that's what takes a little bit of thought to think about the wording on those. With that, open up to discussion by this board. I'm going to go to Devin.
I believe that the applicant's acting on good faith and looking at the criteria, forcing them to move the structure or remove siding that protects it from water damage would be unnecessary hardship. Conditions particular to the property, that would be the setback and the property line that are conflicting with the 2 5/8 inches overlap. The hardship didn't result from actions taken by the applicant. They did build the structure, but the applicant's testimony said that he had talked to the concrete contractor, said he needed to hit these dimensional requirements, and that this kind of happened after the fact, and that the siding was to conform with the need to match the siding of the existing property structure, the home, and with that, I think it is consistent with the spirit and intents of the ordinance and with the values of the village of Pinehurst. So I feel like it's something we could approve, according to what I've heard.
Yeah, that's a good tee up for discussion on those points, so we can jump off from there.
I concur with my colleague.
Bill?
This one is hard. You know, unfortunately, there's nothing about the property itself that drove the
The
failure to
peculiarity.
meet the requirement for the need of the development. And that's one of the driving principles is that it has to be related to the property, not to something someone did. And unfortunately, this was due to the fact we're here because of an error, a human error that was made, essentially. So it's on the face of it, in my opinion, it's difficult because what about the next time? You know, what else is going to come before this board that would have that? So I'm having to think about this one.
Yeah, well, we do treat each one independently, but I do, the peculiarity of the site, does the hardship result from conditions that are peculiar to the property? That's the question.
Yeah, I was deliberating over that as well, and that's where I thought, like, I guess the setback and property line are the closest thing to something related to it. The topography doesn't really apply to it too much. Like,
Right.
they could have moved it elsewhere on the site related to that, but as far as where did this hardship come from, it's because of where it is in relation to that line. That's my understanding.
Ed, what are your thoughts?
Kind of hung up on the same topic as Bill. Like the peculiar, when we have to look at all four and meet all four definitions there, the property didn't drive the issue. It literally is just a human error. Meeting three of them seems very straightforward to me. It's that property one I would need to better understand if anyone has any other input on how to interpret that.
Let me comment, actually, now that I think about it more. As it relates to the topography and the property, and we're having problems throughout the community, but the stormwater issue has become very, very significant on Morganton Road. And I am quite suspicious that their property is probably impacted or will continue to be more impacted than they realize as we see more development. So I think that they're aware of that, having to have raised that pad. I think they took that into account. And I guess I would argue on their behalf that they were pretty thoughtful, and I think Alex's point in terms of their trying to work with staff to reach a fair accommodation here with certainly wasn't an egregious attempt to run around anything here. So I guess that's why I'm inclined to take my Dr. No hat off and move forward with a.
If I think about what you're saying, Bruce, is because of the intrusion of water, they had to raise it on that property.
Right.
So that kind of created some of the challenge that they're in today.
Forced them to make that.
So it makes it impossible to now move it 2 5/8 inches.
Or an undue hardship.
Or an
Yeah.
undue hardship.
Yeah.
So this is one of those situations where, in other situations, again, this is not based on, I'm not providing evidence here, right? I'm just going to state facts. In other situations, because we're kind of struggling with applying this type of after-the-fact review like we've had in other cases, and then, obviously we're worried about future cases, and we should be. We look at each one on its own merits, right? So the board can consider the peculiarity to this property and the fact that, they had, good faith effort was made. They looked at what analysis they wanted to decide on meeting that 5-foot setback, that's kind of moot at this point, right? It's after what happened after securing that development approval, did that site condition potentially change in between? So it's kind of fluid if you look at the site in that situation, right? Before you look at it independently without any type of development approval or without anything happening, then you have these sort of stages in between that could change what that site condition is. Does that make sense?
I think so, but I might need to think about it.
Yeah, that, because I was thinking in relation to the topography, I think it's almost more the location with the pad that is the hardship that is resulting, because that elevated pad, once that was constructed, they can't build their shed elsewhere, right? Whereas the topography, that they could have an elevated pad anywhere on the site and avoid the stormwater. But I guess with just what Alex was saying is the fact that that elevated pad happened after the application was made, does that make it not, I guess, relevant to that process, or does that mean it only follows under the, it wasn't the actions of the property owner versus a condition peculiar to the property? I don't know if I'm wording that correctly, Alex, if that.
Well, I think this is the point of discussion in any after the fact, because there's always going to be undue hardship in a redo scenario. It's how peculiar are the circumstances of that property that led to this, and it can't be, based on the letter C, it can't be hardship created by the applicant to get you there. So it's got to, we want to feel that we're demonstrating that it is peculiar to the property, that hardship, now that there's a building there. Because there is a building there. And we can't really, I don't think we can say, well, let's imagine what we would do if this was, before the fact. I mean, we can't do that.
May I ask the applicant a question?
Yes, please.
The fence line, you honored your existing property when constructing that fence, it appears. Is that correct? Okay. Yep.
We're trying to eliminate cutting down trees or,
That was my next point. Obviously, each property, I mean, it's not peculiar that they have trees on their property or that they have a fence, but there was sort of thought out or intentional in how things were placed, which are specific or peculiar to this property. Not all properties have a 3-foot, fence setback from their property, or not all property owners decide to honor existing vegetation on their property. Not leading, just looking at facts.
Sure. So what we need are, we would need a motion considering, one direction or the other. And it, for the purposes of the motion, it can be a split motion, but that goes a certain direction, right? So, but for approval, all four need to demonstrate hardship. So that's what we're thinking around.
And I'm thinking on some past experience. I would like to make a recommendation for the board to consider, and that would be within the motion, if we would consider moving the portion where you're actually making the motion for approval with conditions, or a denial after the findings are made on each of those standards. So a motion would be, I move that I find, or that the Board of Adjustment finds, because these are your findings. That's what we set these up to be, and this is what a court or a judge will look at. I move that the Board of Adjustment find that unnecessary hardship, yada yada yada, all the way through, and therefore I move that the Board of Adjustment approve with conditions, or deny.
Yep. Yeah, move that leading statement towards after. That makes makes sense to everybody working on a motion, whoever that would be. Yeah. I mean, yes, you can, yep, you just,
Want to reemphasize, because I think it got glossed over, there is a standing water problem to the far side of that property. So the shed has to be to this side of the property. I feel like that part got glossed over. So that is unique to this piece of land because there was road flooding prior to that drain line being put in. After the drain line got put in, on the heavy rains, and we have a lot of those,
There's still a ton of road flooding.
a lot of water to that side. So
Yeah. They've closed that section of the road twice in the last, I'd say, 2 months because of the flooding there.
I just want to reemphasize that part. So there is something peculiar to this lot as to why that building is here.
yeah, and so the variance is requesting a variance to the setback requirement, which is only a setback requirement because the building was, wider than, it would have
Of
been
8
to allow a
inches bigger,
5-foot
right.
setback. So it's
I'd like to take-
linear, but there's a little jog there that, what puts you there is not necessarily that, but, again, it depends on interpretation of
It's
the
the
board.
actual framework that's 12 foot. It was just, we didn't take into account the siding and the trim.
Architects get in trouble for that all the time.
Yeah.
I'd like to take a shot at, if Alex will continue to lead me through this. So the Board of Adjustment finds that an unnecessary hardship would result from the strict application of the ordinance. The board further finds that the hardship,
Oh, you need to state the reasons why.
need to state the reasons why. I had problems with this last time, too.
I appreciate you trying.
The reasons why would require the owner to essentially demolish and rebuild the entire structure and relocate it. Further, the board finds that the hardship results from conditions that are peculiar to the property. The topography in that neighborhood is vulnerable to stormwater runoff frequently, and it is common to that particular neighborhood and that property. The board further finds that the hardship did not result from actions taken by the applicant or the property owner who intended to conform with the requirements currently in place in Pinehurst. The contractor made an error, which they are now dealing with. Further, the board finds that the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. I think the comments from staff indicated that the applicant has attempted to comply, went through the appropriate building process, and I think would be quite unfair to be adjudicated differently. As such, I would move that the Board of Adjustment approve the variance request for the property at 35 Salem Drive.
We have a motion by Bruce. Any discussion on the motion as it sits? Is there a second for the motion? Thank you.
I'll second.
Second by Bill. Any discussion on the motion as it sits? Okay, so we'll call for a vote starting from the left.
Aye.
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 No. Motion carries with a vote of 4-1. Thank you to the applicant and to staff. this point, I do need a motion to close the public hearing and to re-enter the regular Board of Adjustment meeting.
I move that we close the public hearing and re-enter the regular meeting for the Board of Adjustment.
Second.
Motion by Bill, second by Devin. All in favor?
Aye.
We are back into the regular meeting. Next meeting date is January 8th, if there will be business for this board. TBD.
So depending on what Planning and Zoning Board may do, it would be prudent if we do have a Planning and Zoning Board meeting that we do meet as a Board of Adjustment to approve minutes,
Okay.
which would further close the record on this case tonight.
Okay.
In case
Good
there were
idea.
any other actions. So also, I made a pitch last month. Would like to have a call to action for anyone who, I mean, Matt, you did, we appreciate you filling in here in the interim, the one time. As
do what I
Board of
can.
Adjustment Chair. You know, typically if we're not having many Board of Adjustment meetings, that's usually a good thing, right? Because there's only a few things that Board of Adjustment has to do, and you're usually not the most comfortable positions. But, you know, obviously the Board of Adjustment role is, the chair role is pretty unique. It's different, and it's the one that could potentially put us in a risky situation, right? But please consider if you would be interested in serving as chair or vice chair. Bill's raising his hand, so.
Told you this before.
All right, well, that is an action that does need a council action there. So let's, I would, yeah. Mm-hmm. Sure. Yeah, I did forget about that background too. Also, we need to look at term limits and other officer roles. Did we settle the chair, the vice chair and second vice chair? I think we did take care of that back in the summer, I believe. All right, good. But if you need staff to send out your term limits, and let us know. You may have noticed, and I may have communicated, I know I've been sending a lot of communication to you all, and that's because I want to keep everyone up to speed. There's things that will be coming your way, and I wanted to be as transparent as I could for a lot of that. But one of the things that has changed is the term limits for you guys are going to be moved back to 3-year terms. So you'll be eligible for 2 full 3-year terms as a member instead of the 3 2-year terms. So we're going to have to kind of cycle some of you guys back in line. Let's say if you've got 1 year left, then your next term will be of 1 year, whatever. So we're going to have to work through that a little bit. That change just got made at the November 18th council meeting as well.
Well, you may need to check mine, because I think my second term that was 2-year is up in January, so.
Is that your last?
Well, I would have 1 more year to get to 6.
Okay.
But when it was approved, it was for 2, so.
So you'd have 1 more.
Mhm.
Okay. That's all.
Okay. Thank you, Alex. Look for a motion to adjourn the meeting.
So moved.
Motion by Bill, second
Second.
by Devin. All in favor?
Aye.
Meeting is adjourned.